Hi, everybody. Thanks so much for signing in to watch this talk. For those of you who don't know me, my name's Daniel Thorpe and I'm a junior barrister at Radcliffe Chambers. And I'm delighted to be joined, albeit virtually, by my friend and colleague, Emma Loizou, also from Radcliffe Chambers. So as the title suggests on the screen, we're going to be speaking on Beddoes and blessings today. The idea of our talks, in line with what our junior programme is all about, is, and again, as the name suggests, is to go back to basics. What are these applications? When do they arise? How are they made? And I'm going to kick things off with what we call blessing applications. The origins of this talk start from the old adage, it's easier to ask for forgiveness than permission. Now, my research attempts could only place that quote back as far back as 1971 and this slightly random line from the Reader's Digest in America. But the principle is obviously a universal truth, at least domestically from my experience. But to what extent should it apply, or does it apply to trustees? So trustees, whatever their circumstances, ought to be aware that they're subject to various onerous duties when acting in relation to their trust. The follow-on from that, obviously, is that when exercising their powers, the trustee should be satisfied as to the propriety and the appropriateness of what they're doing, particularly when they're making what might be described as a momentous decision. But what if they're not so satisfied? What if they are about to do something that they are not sure about, or if, something that they're worried about the consequences? Do they crack on confident, or confidence to a certain extent in their ability and in their course of action, potentially in the face of hostile beneficiaries, which, as we all know, do exist, only to find out later on that they breach their duties and have to, as a result, ask for forgiveness of the court or of their beneficiaries? Or is there an alternative by which permission can be obtained, which essentially gives the trustees a license to do as they propose, but once permission has been obtained, safe in the knowledge that challenges will not follow? And to what extent is this alternative, if it exists, easier? So my talk is about this alternative option, when trustees can go to court to ask the court to bless a proposed decision. So on that note, no private client talk would be complete without a reference to the Wong litigation. And the facts and significance of these decisions have been talked about at length and with far more expertise by others. So I'm not going to dwell on the specificities, but you'll see from the slide there that Lord Richards made that remark with relation to the Global Resource Trust trustees' decision in September 2005, which in essence transferred the entirety of the assets of the trust to another trust, the Wong Family Trust, putting them out of reach of those who might have been otherwise entitled. And he says there that a trustee who is in genuine doubt about the propriety of any contemplated course of action in the exercise of fiduciary duties and discretions is always entitled to seek the guidance of the court. Now, this is recognised as a general principle, a cardinal principle of trust law. But I suppose the question for us now is, how might such an application take place, and in what circumstances will the court actually intervene in the exercise of trustees' power? Now, the answer in part is given by the case of Public Trustee and Cooper and what has become known as a result as the Public Trustee and Cooper jurisdiction. Now, this is a case where trustees sought the court's guidance on whether or not they could properly accept a bid to purchase shares which were held by them subject to their trust. Now, apologies for the slightly lengthy slide, but I think it's useful to spell out each of the distinct situations referred to by Mr. Justice Hart, who I should say was in turn quoting an unreported judgment of Mr. Justice Robert Walker. So the first category, category one, is where the issue is whether a proposed action of the trustee is within the powers that are conferred upon them by the trust instrument or otherwise by statute. The second category, category two, is whether the proposed course of action is a proper exercise of the trustee's powers, and the trustees have decided how they want to exercise them, but because the decision is particularly momentous, they want to obtain the blessing of the court. So category two is a true blessing case, if you like, and we'll go on to discuss that in a little bit more detail later. The third category is that of surrender of discretion. And that's where the trustees essentially say to the court, well, we don't know what to do. What should we do? There's no proposed course of action. It's simply a case of surrendering the choice that they could have made, ought to have made to the court. And the fourth category is essentially a challenge to the trustees' actions which have already been taken. And as it says there, the action is attacked as being outside their powers or an improper exercise. I'm going to go through these in a little bit more detail just for completeness. So looking at the first category, this is an extent of the trustees' powers question. So this is essentially a construction case, sometimes referred to as a construction summons. The trustees are essentially coming to court to define the extent of their powers. Can we make this decision or not? Do we have the power? And it's common for these matters to be heard in open court. The court will often be interested in hearing argument from opposing sides. I've said on the slides that you should consider necessary parties. There's obviously scope for representative parties, so that depending on the facts, certain classes of beneficiaries are represented by one beneficiary, for example, rather than 5, 10, 20 people being joined to proceedings. And a couple of sundry points which I think are worth bearing in mind. If a trustee is faced with a construction issue, Section 48 of the AJA 1985 should be borne in mind. And that provides that where a question of construction has arisen and the trustees have obtained an opinion from suitably qualified counsel, the High Court can make an order authorising the trustees to act in accordance with the opinion without hearing argument. So that's a nice little shortcut there, but clearly not appropriate if there is any sort of dispute on the facts. And second, it's relatively common for trustees on this sort of application to include a claim under Section 57 of the Trustee Act 1925, which gives the court the power to give trustees a particular power subject to conditions for a particular purpose or a particular transaction. A situation where that might occur is where a construction application is made. It's found that the trustees do not have the power to do something, which in all the circumstances of the particular case is urgent. And the court there can be asked to authorise the trustees to do that particular urgent thing, but no more. I'm going to take these in a slightly peculiar order, as hopefully is clear from the title of this talk. But the fourth category is where an exercise of powers is being attacked. And I don't need to spend too much time on this. It's clear from the slide there, the sort of things which are an issue for this sort of category 4 case. It's classic breach of trust, classic challenge to trustees, the exercise of trustees' powers. And I think each of those things could probably warrant a talk in its own right. So moving swiftly on to the third category. Now this warrants a little bit more attention because it's quite closely associated with the second category that we looked at before. But the third situation is where the trustees are surrendering their discretion to the court. And the picture probably gives it away there. But this category of case should really be seen as a last resort. In Public Trustee and Cooper itself, the examples given by the court were that the trustees are genuinely deadlocked or are disabled because of a conflict of interest. Now, the court views a surrender of discretion with very little enthusiasm, and I think it's quite easy to see why if you take a step back and think about it. So as a general rule, trustees cannot be compelled to act as trustees, and so have accepted their office in accordance with the terms of the trust. The court's view, therefore, is that it's the trustees who are best placed to exercise the discretion which is given to them by the trustee or indeed by statute, not the court. And I think for this reason, there are few reported cases in England which fall within this category. But one of them, which was reported in 2019 and referred to on the slide there, is A, B, and C, D. Now, in brief here, there were two discretionary trusts which were created for the benefit of certain family members. AB was a professional trustee, and the other trustees were lay trustees and part of the family who, in summary, were seeking to exclude certain children on the basis of personal and family reasons. Now, AB was obviously a little bit concerned about this. basically was of the view that this might not be a legitimate thing to do. And so AB was of the view that the court should intervene to break the deadlock and essentially exercise the trustees' discretion in their place. Master Price gave 2 judgments. At first, it was ordered that the trustees essentially go away and find a compromise. And the rationale there was that category 3 cases are a last resort. The trustees should find a way in which they can lawfully exercise their discretion. However, the trustees were perhaps unsurprisingly unable to find a route through the deadlock. So they came back to court, and in the second judgment, Master Price exercised on behalf of the court what ought to have been the trustees' discretion and wound up the trust. Sometimes surrender cases, category 3 cases, are talked about in terms of special circumstances. According to Master Price in A, B and CD, the special circumstances of that case were that without the court's input, it seemed like professional trustees might need to be appointed, or more professional trustees. This would take additional time. It would take a lot more money. Master Price also said that further litigation might be necessary. Again, this would cause the incurrence of more legal fees and would cost some time. And it was also said by the judge that it was obvious that certain of the lay trustees were intransigent. So there was really no way through here. So sooner or later, the court was going to have to intervene. The take-home point is that really do think of this category as a last resort. In A, B and CD, there was genuine deadlock. And in those circumstances, that is when the court stepped in. But it really should be, as I say, a last resort. And before going on to category 2 cases, so blessing cases properly, it's worth mentioning that sometimes, and this is alluded to in Public Trustee and Cooper itself, there will appear to be an overlap between the classes of case. This is perhaps no more so than between categories 2 and 3, blessings and surrenders. The first case cited on the screen involving the late, great Bob Marley was where the Privy Council suggested that where the trustee seeks approval, he surrenders his discretion. And the quote there or exemplifies that approach. However, and despite occasional attempts by counsel to raise this case in argument, alleging that trustees have in fact surrendered their discretion, it's pretty much settled now that a blessing case is distinct from a surrender case. The 2 cases on the slide are simply examples of that. Rees over Capital was a recent decision of Mr. Justice Miles, in which he recognised that where a trustee has made a decision but seeks approval, there is no category 3 surrender. In other words, he maintains the distinction between blessings and surrenders. And to take an offshore example, in re-ABC trusts, the Bermudan Supreme Court had no difficulty in dismissing counsel's attempts to elide categories 2 and 3 by reference to Marley and maintain the distinction between the 2 classes of case. Now, it is sometimes going to be appropriate to ask for both. So before looking at category 2 specifically, sometimes, in other words, you can ask for a blessing, but in the alternative, ask for directions which essentially do involve a surrender. The simple example is summarised on the slide. Imagine a situation where trustees are involved in a hotly contested situation with aggressive and hostile beneficiaries, and they decide that certain trust assets should be sold, but all of the beneficiaries disagree with each other. So a potential solution here is that the trustees go to court. Their proposed momentous decision is the sale of the trust assets, but the court says, no, we're not going to bless that decision. Well, in the alternative, it's open to the trustees to say, well, in that case, we ask the court to exercise we surrender our discretion to the court, and the court should give directions as to what happens next. This has certain advantages, not least that everything is kept under one roof of one set of proceedings, and it'll hopefully lead to a binding result and a way through the quagmire. And so on to blessings proper, a true blessing application. As Lord Richard said in Wong, and indeed as was said in Public Trustee and Cooper itself, we're concerned with momentous decisions. So what types of decision are momentous? Now, this will really depend on the facts of your case, but I've given a few examples on screen. The first is the South Downs case, The relevant decision there was whether the trustee could sell the trust's entire interest in a holding company. In Brown, the question was whether or not an executor could purchase an estate property. So there are obviously allegations or concerns of self-dealing. In the RSPCA case, the decision was whether or not the charity could adopt a membership policy, which in essence would allow it to kick out of its membership those who had joined despite being campaigners in favour of hunting, and who were trying to change the charity's policy from the inside. And in X and A, the trustees were proposing to exercise a power and apply the trust fund to charitable causes. As I say, those are just examples, and the upshot is that there are a variety of contexts, and there's no hard and fast way of identifying a momentous decision. And I suppose in that light, there's nothing to stop what might be considered to be an ordinarily straightforward decision, or something which we might say should be is not momentous at all in the ordinary course of things, from becoming momentous based on its context. So, for example, again, to refer to hostile beneficiaries, if a trustee finds him or herself or itself in a situation where the beneficiaries will jump on the trustee after any decision has been made, or will constantly threaten litigation and is constantly writing to the trustee to say that we're not happy with what you're doing, that might change the nature of the decision that's being taken by the trustee from something which is ordinarily harmless to something which is now momentous, in which case the trustee should not necessarily be deterred from applying to court. And if that application is made, what is the approach of the court? And this test, as I've put on the screen, comes from Public Trustee and Cooper itself, but it was also expressly acknowledged in the Earl of Cardigan case, cited at the top of the screen. Now, earlier in that decision, Lord Justice Foss approved the tripartite structure set out on the slide, and just to go through that very quickly. The first question for the court is whether or not the trustees have in fact formed the opinion that they should act in the way for which they seek approval. Now, this is obviously a factual question. It'll depend on the evidence before the court, and I'll touch on that evidence and the necessary level of disclosure shortly. The second question is whether or not the decision is one which a reasonable body of trustees properly instructed as to the scope of their powers could properly have arrived at. This has two strands, as set out by Mr. Justice Arnold in the BA pensions case cited on the slide. The first is that the court will look at the process of the decision. What has the trustee taken or not taken into account? Has expert advice been obtained? Can the expert's advice reasonably be relied upon in the circumstances? Have all of the necessary formalities been complied with? And after that, the court will look at the outcome. Is it rational? And then the third question is, are there any conflicts of interest? And if so, have they been dealt with satisfactorily so as not to have vitiated the decision? So how will the court approach those stages? The answer is given quite nicely by Mr. Justice David Richards, as he then was in ReMF Global. Generally, in blessing cases, the court's function is limited. This might be contrasted with Beddoe applications, to preempt what Emma is about to say. But trustees, as I mentioned earlier, are seen as the best persons to exercise the discretion afforded to them by the trust instrument. The court will consider whether the decision falls within the scope of the trustee's powers, and if it does, it won't seek to substitute its own decision in place of the trustees. The question is simple. Could a rational trustee have reached this decision? If the answer is yes, the fact that the court would have done something different is irrelevant. So far, so easy, but it's important to bear in mind a couple of health warnings. And this is not a case of simply rubber stamping something, although admittedly in some offshore jurisdictions, it does feel a little bit like that. The court, despite its limited role, will exercise caution and will refuse to bless the decision unless it's satisfied as to the trustee's conduct. The impact of a blessing is that beneficiaries are unable to complain after approval is obtained. This has the knock-on impact of effectively extinguishing a breach of trust claim in relation to the same decision. But on a blessing application, the court is operating in a very different position to how it would be operating in such a breach claim. For example, there's no cross-examination or full disclosure of trustees' deliberations. And so the court will, as I say, exercise a little bit of caution. And there's a quote there on the slide from Tamlin and Edgar, which summarises that quite nicely. And this is why, in looking now at key points, take-home points for these applications, the first one, top of the list, is disclosure. Now, this is a decision of the trustees and not the court. The court must stand possessed of all the relevant information so that it has a proper understanding of what the trustees have done and why. This is essentially a duty of full and frank disclosure. A relatively good example of this, and it's difficult to take too much from the Piedmont case, is Piedmont and Riviera from Jersey. Now there, the trustee took 2 years and 8 months to consult with beneficiaries over the proposed decision relating to the restructuring of the trust. Detailed evidence and records were provided to the court. So the court had a good idea of what was proposed and what had been done to date. And now the consequence of failing to give proper disclosure, or the consequences, are made clear from A1 and R1, which is a Guernsey case, where despite finding that the outcome of the proposed decision was not unreasonable and was rational, there was what the court described as an unforgivable failure of disclosure, which meant that it was impossible to discern in the circumstances what the trustees had in their minds at the relevant time. So the application was dismissed. I would just caveat that slightly by saying in the Earl of Cardigan case, which I referred to earlier, and this is at paragraph 61, that it was said that the court, whilst the court may send the trustees away to produce more evidence, it might not refuse to approve a proper and momentous transaction on a technical ground based upon an incidental failure to produce adequate material to the court. So potentially they're leaving the door open for perhaps an adjournment or some other direction for the trustees to go away and put more evidence before the court. But in my view, better not to ask the question. And if you're tasked with drafting one of these applications, give yourself or your clients the best possible chance of getting things sorted out first time around, and get all or as much evidence in as possible as to the process of the trustees' decision. Now, linked to disclosure is the court's assessment of reasonableness and rationality and when that assessment will take place. The court will assess reasonableness and rationality as at the date of the hearing, not simply as at the date of the trustee's decision. And the authority for that proposition, which my apologies, the reference is on the next slide, but it's Brown and New Quadrant Trust Corporation, which was the case in 2021. Now, this means that if circumstances have changed materially since the trustees made their decision, but before the hearing of the blessing application, the trustees will need to update the court as to what those changes are and how, if at all, it impacts on their decision. And it's also important to bear in mind, that's the second key point on the slide there, that the court will look at the trustees themselves. So in Jones and Firkin Flood, Mr. Justice Briggs declined to approve the trustees' proposals, and in view of their conduct, actually removed the majority of them. He was, he said, justified in his refusal to bless the proposal, given the trustees' conduct. He also left open the question of whether the court will become more involved in cases such as this, namely where trustees are found to be unsuitable. On to the third set of key points. It's also important to canvass the beneficiaries' views. I've already mentioned Piedmont and the consultation process undertaken in that case, but it should be borne in mind that with proper consultation and engagement, it may be that a blessing application is not necessary at all. and beneficiary consent might give the trustees satisfactory protection. As to the options for beneficiaries themselves, those who feel strongly either way about the trustees' proposals will no doubt want to be involved in the process, either directly or via a representative party. And even if a decision is blessed, a disappointed beneficiary might wish to consider whether the timing of the application might lead to a claim. Specifically, has the delay led to some sort of loss or other consequence if the trustee might have been said or might be said to have been able to apply earlier? Now, I've mentioned the Brown case on the slide, and as I mentioned, that's authority for the date of the court's rationality assessment. But in that case, the opposing beneficiary actually got on the front foot and brought a claim for an injunction to prevent the trustee from selling a trust asset. Now, unfortunately for Mr. Brown, this claim ended in the court blessing the proposed sale. But beneficiaries should also bear in mind that they need not wait for the trustee to act before taking action on their own. That injunction avenue is open. Moving on to procedure and costs, and I'd say just a final word on the Brown case. Interestingly, or relatively interestingly, the trustee's blessing application in Brown was made by way of a counterclaim. So whilst ordinarily, as it says on the slide there, such applications are made via parts 8 and 64 of the CPR, the court rejected Mr. Brown's argument that the avoidance of part 8 here was fatal to the trustee's claim. The court was of the view that if the trustee were to issue a second claim, as opposed to simply counterclaiming against Mr. Brown's claim for an injunction, that would be duplicative and disproportionate. I touched on representative parties already, but it's also worth mentioning costs. Now, costs in proceedings such as these probably warrants its own talk, and Emma's going to deal with Beddoe applications and costs in a little bit more detail. But the take-home point here is this: is the application really necessary? Even if you get home on the blessing, if the court considers that the trustees have acted unnecessarily, that criticism will sound in costs. And finally, a potential trap for the unwary, buried in Practice Direction 3E, is a mandatory provision requiring anyone who intends to get their costs out of a fund or claim their costs out of a fund to file and serve on all other parties written notice of that intention with a costs budget. So for a Part 8 claim, filing and service of those documents needs to be with the witness evidence in support of the claim. Now, it's true that there's no sanction given in Practice Direction, and the question of whether or not there's an implied sanction is again probably material for another talk. But there is at least one member of our chambers who would argue that a failure to comply with this paragraph means you're limited to the costs claimed on your claim form, i.e. the court fee. I'm not so convinced that you would find favour with many judges. And in any event, the trustees, of course, have their usual indemnity. But if you happen to be, Steph, I'm going to do that paragraph again. Now, there's no sanction, and that does leave open the question of whether or not there's an implied sanction, which itself is, again, probably material for a talk of its own. But there is at least one member of our chambers who would argue that a failure to comply with this paragraph, that means you're limited to the cost claimed on your claim form, which ordinarily will, of course, be the court fee. Now, I'm not so convinced that that would find favour with many judges. And of course, the trustees will be entitled to their usual indemnity. But my advice is don't ask the question or don't allow the court to answer the question and put in a cost budget. So that leads us to the conclusion. Is forgiveness easier to obtain than permission? I think for trustees, the answer is quite often no. So thanks very much for listening, for watching. I understand the slides are going to be made available for anybody who wants them, but it's now time for me to hand over to Emma.
Hi everyone, I'm Emma and I'm going to be talking about Beddoe applications today. My talk will look at the general legal framework, what a Beddoe order is and why it's useful, when and when it's not appropriate to get one, how the court approaches Beddoe applications, and the procedure for applying for a Beddoe order. I'm going to refer to trustees throughout my talk, but the same procedure generally applies for executors and administrators. Starting with the general legal framework, the starting point is that trustees are entitled to pay or to be reimbursed out of the trust fund all expenses properly incurred by them when acting on behalf of the trust. And we get that from section 31 of the Trustee Act 2000. When we look at the civil procedure rules, rule 46.3 provides that where a person is or has been a party to any proceedings in the capacity of trustee, and we're not dealing with the situation where costs are payable under a contract, then the general rule is that the person is entitled to be paid the cost of those proceedings, insofar as they're not recovered from or paid by any other person out of the relevant trust fund and assessed on the indemnity basis. We then get some further guidance from the practice direction. So paragraph 1.1 notes that the trustee's indemnity is available when costs have been properly incurred. And whether costs are properly incurred depends on all the circumstances of the case and includes whether the trustee obtained directions from the court before bringing or defending the proceedings, whether the trustee acted in the interests of the fund or in substance for a benefit other than that of the estate or trust, including the trustee's own, or whether the trustee acted in some way unreasonably in bringing or defending those proceedings. There may be varying views as to whether proceedings have been properly brought or defended, and there's a danger that a trustee may have to pay the costs of the main action personally if they're unsuccessful. So, as a result, trustees who have contemplated bringing or defending legal proceedings, they typically want to get some assurance that their legal costs are going to be paid out of the trust fund. And this is to avoid that risk that later on, at some future date, there's a challenge to their entitlement to an indemnity. So, in the case of Beddoe, a life tenant of settled land had requested title deeds from the trustee so that she could sell the land. The trustee obtained advice from counsel and resisted the request, then defended proceedings brought by the life tenant and was unsuccessful. The trustee was asked multiple times during the course of the proceedings for those title documents. The judge ordered that the costs of the action be paid out of the trust fund, and the beneficiary then appealed to the Court of Appeal. Now, the Court of Appeal refused the trustee from taking all the costs out of the trust fund, and the trustee was only entitled to the costs that he would have incurred had he applied for leave to defend it. And Lord Justice Lindley, who gave judgment in that case, noted that a trustee who, without the sanction of the court, commences an action or defends an action unsuccessfully, does so at his own risk. The judge also went on to note the ease and comparatively small expense with which trustees can obtain the opinion of a judge. And that's something that I'll return to at the end of my talk. Lord Justice Bowen similarly mentioned the inexpensive method of solving a trustee's doubts in the interest of the trust by essentially applying to the court. So this is where the Beddoe order essentially comes from. So what is a Beddoe order? Well, the Beddoe application is an application to court for directions as to whether or not trustees should bring or defend proceedings in their capacity as trustees. The Beddoe order authorises the trustee to do that action and to be indemnified out of the trust fund for costs incurred in those proceedings. And that includes costs that they might have to pay another party at the end of the proceedings. Such an order removes the risk of the later challenge to that trustee's indemnity, and so determines that aspect in advance. What it doesn't do is determine the issue of costs between the trustee and the other party, or parties to the main proceedings. So if the trustee is unsuccessful, they may still be ordered to pay the other party's costs, but they'll be able to dip into the trust fund to pay them. The advantage of the Beddoe order is therefore that the trustee can determine in advance whether it's proper for them to engage in litigation and to meet those costs from the trust fund. When is it appropriate? Well, there's some cases where it's so obvious that a trustee will not be indemnified in request of their costs. So, for example, if they're successfully sued for compensation for breach of trust, or whether they take an unsuccessful position in hostile litigation between rival claimants to a beneficial interest in trust assets. Now, for cost purposes, disputes involving trustees are usually divided into three categories, and that was identified by Justice Lightman and Alsop Wilkinson and Neary. But these categories are discretionary and they can overlap. Now, broadly speaking, the three categories are trust disputes, beneficiaries disputes, and third-party disputes. So trust disputes are disputes as to the trust on which the trustees hold the assets of the trust. And these can be friendly, for example, an argument over the construction of the trust, or they can be hostile, so a challenge to the validity of the trust or a claim by one beneficiary to the share of the other. There's also beneficiary disputes, so these are disputes between the trustees and beneficiaries, and they concern generally the propriety of the action which the trustees have taken, omitted to take, or may in the future take. So, for example, it might be where a beneficiary sues a trustee for breach of trust. Third-party disputes don't concern the internal workings of the trust, but they're disputes with third parties as to the rights and liabilities assumed by the trustee in the administration of the trust. So these are things such as breach of contract or tort claims brought by or against third party, or a claim by the trustee against a former trustee for breach of trust. So the main circumstances in which a trustee is likely to make a Beddoe application is a third-party dispute. Now, usually the trustees and beneficiaries' interests in these are not normally in conflict, and so the trustee puts forward the claim or defence against the third party. If we're looking at friendly trust disputes, then it might be quite clear that those proceedings are going to be for the benefit of the whole trust, and so the trustees will obtain the indemnity. But in these circumstances, there wouldn't seem to be a useful purpose served by such an application, and might generally be considered to be a waste of money to apply for one. And for hostile trust disputes, then the trustee should normally remain neutral and allow the rival claimants to fight it out. A Beddoe order is not generally appropriate in beneficiaries disputes. These are ordinary hostile litigation, and so costs will follow the event and not come out of the trust fund. Mainly because the court might not be able to conclude whether the trustee has acted reasonably or not until the claim is concluded. So those are the circumstances where they're appropriate usually, but the one consideration trustees need to think about is whether there's an alternative way forward and whether applying for a Beddoe order is actually necessary in the circumstances. So if all the beneficiaries of adult age and of capacity and they consent to the way forward, then it's unlikely to be necessary. But if the trustees are also adequately indemnified against costs in any event, then applying for Beddoe relief is similarly likely to be unnecessary. So if there's a specific indemnity clause in the trust deed in respect of that litigation, or the beneficiary is given indemnity that litigation costs can be met by the trust fund, then it's unlikely to be appropriate. And trustees may also be able to get cost protection by way of insurance protecting them in the event that they're unsuccessful. It might also be the case that it's just so clear how the trustee should proceed that the cost of making the application is just not justified when considering the size of the fund or the significance of the matters in issue. And sometimes this might seem the case at the outset, so it might seem issues are straightforward and the trustees might be reluctant to incur the costs of a Beddoe application. But if it later becomes apparent that actually the litigation is more complex and is much more protracted, then at that point the trustee should make a prompt application for a Beddoe order. So the application's been made. What will the court consider? Well, the court will consider whether the trustee's proposed action is in the interest of the trust. So the court's going to consider the merits of the main proceedings and the likely cost consequences. It's essentially a risk assessment. What's the likely outcome? What's the likely cost outcome? Who stands to benefit? And what's the amount in issue? And these types of cases are very fact sensitive. There is some degree of overlap with the public trustee and Cooper application, which Dan Thorpe has been speaking about. That since a Beddoe application often requires the court to bless their decision to be involved in, or not be involved in litigation. But in a Beddoe order, the court's approach is different. So when the court is doing a public trustee and Cooper application, what it's not doing is substituting its own decision, but it's considering whether the decision is one the trustee could properly have arrived at. With a Beddoe, the court's role is more involved. The court is going to take a more inquisitorial role when it's asked whether to approve a decision to engage or not engage in litigation. And we get some helpful guidance actually in a Jersey case, so the F Charitable Trust case from 2017. There, the court noted that where the underlying foundation of the decision is a matter of litigation, the court's role is different. Litigation is something which the court is familiar with, and probably more so than the trustee. Now, where the trustee is seeking to have a decision to litigate blessed by the court, it should expect the court to exercise a more direct inquisitorial role, and so be ready to form its own judgment as to whether it's sensible for the trust to be put at risk by that litigation. Now, if the court gives directions allowing trustees to take, defend, or pursue litigation, it may limit the indemnity, for example, up to a particular stage, so that the trustees then need to come back to renew their application before they continue with proceedings. In those circumstances, the court will, if possible, deal with the matter without a hearing. But the court may also restrict the amount of costs in respect to which the trustee is entitled to an indemnity. So allow the indemnity, but only up to a particular level. So in a recent case, Attorney General and Zedra Fiduciary Services UK Limited, and that case concerned litigation over the National Fund Charitable Trust Fund, the court gave permission to the trustee to use the trust funds for the purpose of pursuing an application for permission to appeal, but it limited that further sum to £25,000. The judge there did not place a cap on the appeal itself, the cost of those. So a Beddoe application is made by Part 8 claim form, and it's usually under Part 64.2a. And there's quite a protracted procedure involved, and the practice direction provides quite detailed guidance on the procedure. And I'm going to recap some of it here. So first, it's brought in separate proceedings. It concerns a different issue and affects the beneficiaries of the trust. It usually concerns sensitive and confidential matters of which the parties to the main proceeding should not actually be aware. So, for example, the merits of the claim. And for that reason, it's heard by a different master or judge, the one assigned to the main proceedings, and it's normally heard in private. Because confidentiality can sometimes be quite important, then as regards to claim form, the trustees can express the remedy in quite general terms, but the evidence must set out exactly what they want to do. There's an emphasis in the practice direction on dealing with the matter without a hearing. So the court can dispose of the application without a hearing if it will save time, expense, and a hearing is just not necessary. So the trustees should consider in advance whether a hearing is necessary, and if so, explain it in the evidence. Simply because there's a dispute between the parties over directions will not necessarily mean that a hearing will be directed. If the matter is urgent, for example, we're getting nearer the end of the limitation period, or there's a deadline for service, then the court may be able to give directions on a summary consideration of the evidence, and so consider steps up to a certain point, those that need to be taken urgently, but then limit it so the application must be renewed at a later stage. In terms of parties, trustees will usually be the ones making the application, since it is them who need the indemnity, and beneficiaries are the defendants, though it's usually unnecessary for them all to be joined. For example, the trustee may advocate one view of the proposed course of action, and another beneficiary may advocate the other. Sometimes no defendants may be needed, and so the court can assess the application simply from hearing from the trustee. If the trustee thinks that's the way forward, and that's the case, then they can apply before issuing the claim form to issue it without naming any defendants. But if it's so straightforward that there's going to be no defendants and no beneficiary needs to be joined, then there's a question as to whether the application is actually necessary in the first place, or whether this is an example of a case where it's so clear-cut that the Beddoe application isn't necessary. If there's doubt as to which beneficiaries need to be joined or given notice, for example, there's a large class of discretionary beneficiaries, then the trustees can apply to issue the claim without naming the defendants and make an application for directions as to who to join or give notice to. And for a charitable trust, the Attorney General is always the appropriate defendant. In terms of evidence, these are my witness statement, and they must disclose all the relevant matters. Otherwise, the trustee may not be properly protected by the order that's made. So if some important fact has been omitted, which would have persuaded the court not to make the order, then the trustees may still be at risk as to costs later on. The witness statement will likely need to be quite detailed and address the underlying proceedings, give details in relation to the trust, for example, the value, distributions, appointments. And the trustees also need to support the application with a variety of matters. So trustees need to get the advice of an appropriate qualified lawyer on the prospects of success. And an appropriately qualified lawyer is someone whose qualifications and experience are appropriate to the circumstances of the case. So they must state the qualifications and include the instructions also. Where a child is a defendant, then the court will expect to have the instructions and advice of an appropriately qualified lawyer as to the benefits and disadvantages of the course of action from the point of view of the child beneficiary. So here we've got two potential pieces of advice that are needed. The trustee also needs to provide an estimate of the value or other significance to the trust estate. the significance of the issues in the proceedings, the costs likely to be incurred by the trustees in the proceedings by reference to the principal stages, the cost of the other parties, and any known facts concerning the means of the other parties to the proceedings, and any other relevant factors that the trustees consider should be included. Now, there's also an emphasis on sort of front-loading the matters which the trustees need to deal with. So they should address in the witness evidence what practice direction, whether the practice direction or pre-action conduct has been complied with, and whether they propose to undertake mediation, whether they've undertaken mediation, and if not, why not. And the evidence should also address what consultation there's been with the beneficiaries and with what result. And the practice direction gives some examples of what consultation is generally expected. So if we're looking at a private trust, if there's limited beneficiaries and they're all mainly adult and traceable, then the trustees are expected to have canvassed with them the course of action. If there's a large number and there are unborns and children, then there still may be adults with whom the trustees can consult. And now the trustees may be slightly concerned about what they included in the witness statement when there's a beneficiary who's a defendant, but that beneficiary is also a party to the main proceedings and has our interest, which is opposed to the trustees, so they're hostile. Clearly, the trustees don't want them to have privileged material, for example, the advice on merits. So in those circumstances, the advice should still be put in evidence as exhibits to the witness statement, but not served on the beneficiary, unless there's been no harm by the disclosure. The beneficiaries may also be excluded from some parts of the hearing, for example, when the merits are being discussed, and if there's an issue over what needs to be excluded or not, then the court may need to be asked to adjudicate on that. In terms of costs, well, generally the cost of the parties are normally, in the absence of improper conduct, paid from the trust fund. So it may be the case that the attitude adopted by one beneficiary has made the application necessary, and because of them, that they will not get their costs and might face an adverse cost order themselves. And something that's been raised by Dan as well in his blessings talk, and parties who want to seek their costs out of the trust fund must generally give notice of intention to do so. So that brings us to the end. But at the beginning, I quoted Lord Justice Lindley, where he referred to the ease and comparatively small expense with which trustees can obtain the opinion of a judge on the question of whether the action should be brought or defended at the expense of the trust estate. Now, as we've seen, the procedure is quite involved and it requires costs to be incurred at the outset. In certain circumstances, the advice of 2 lawyers is needed. Trustees need to give full disclosure, consult with beneficiaries in advance. So there's quite a lot of front loading and incurring of costs at the outset. And as a very extreme example, on Howard versus Lees-Millais, the Court of Appeal referred to a Beddoe application, which lasted 8 days plus 4 days on costs, as well as interim hearings and appeal, and where a substantial amount of costs had been incurred. Now, in that case, the claimants were the trustees of 2 settlements. They'd issued a Beddoe application seeking the court's approval to pursue various claims for breach of trust and other relief. The defendant beneficiaries were not in favour of the litigation, except for one particular professional negligence claim against a firm of solicitors. And the judge agreed with the defendant beneficiaries and only sanctioned that negligence action. And there was thereafter a dispute over costs. Lord Neuberger, when he was Master of the Rolls, described the circumstances as unusual, complicated and disturbing, but also said the possibility that an application of that type would involve well over 12 days of court time, would require more than 3,000 pages of evidence, would take some 5 years or more than 18 months if one ignores the cost issue to resolve, and would incur the parties in costs exceeding the equivalent of £1 million in present day value, would have seemed inconceivable to those 2 experienced judges. This should never happen again. So that brings me to the end of the talk. If you haven't had enough of Beddoes and Blessings, then I'd suggest you check out the talk from the Private Client Conference in 2021. But otherwise, thank you very much for tuning in.